Friday's the hard day. Friday's the hard day. And then on Friday, so Friday morning, send it today. Yeah, we'll send it Friday morning.
We're just waiting for Baron. And then we'll get started.
Everybody's gonna be going like this pretty soon. Sweating. Well, that looks good. All right. Where's Betty on the board? All right. I donate the bottle. Yeah, the machines are really tough on me. I came down and I go upstairs right away. The budget was done. What machine are you on? I was kidding.
By the time I leave, I will have to get back.
Thank you. That's a break even kind of deal.
Usually I put a little bit
You're
more.
supposed to leave after you win, but that's what happens. You win right away and you want to stay.
What's worried? I'm not worried about that.
What on Ferd?
Come up and I stand there,
Where were they going? Oh, sorry, I'll go get you.
So for this water permit issue, I think this So I think, yeah, to circulate this and figure out, like, whatever language you guys want to put in there, however we need to do it. Yeah, you have to.
Okay, we're waiting on Baron, but I just want everybody to know that we did have a discussion after we went on recess, and Eddie, do you wanna? After the recess, we got together, and what we've decided with White Earth is to issue a letter immediately to Governor Walz, and you can see the letter that was just drafted behind you or on your screen for the Zoom people, requesting for rescinding of DNR dewatering permit. And it's my signature, but it says, I write to you today on behalf of the Minnesota Chippewa Tribe regarding the water appropriation permit amendment number 2018-3420 construction dewatering that was issued by the Minnesota Department of Natural Resources on June 4th. Pursuant to Minnesota Statute 103G2.271, the White Earth Reservation was not given sufficient notice, nor did the Department of Natural Resources engage in consultation with the White Earth Reservation in violation of Executive Order 1921. The permit amendment increases the amount of water that Enbridge Line 3 replacement project may displace from some 510.5 million gallons to 4,982 million gallons. This is a 10-fold increase in the originally approved water appropriation permit. While there was a conversation between a White Earth staff person and a DNR staff person, there was no attempt made at a government-to-government consultation prior to issuing this permit on June 4, 2021. Given the high temperatures and the low precipitation, it should say this season, right? Northern Minnesota is in a moderate drought. Water levels are already dangerously low, and displacing this many gallons of water will undoubtedly have a detrimental impact on our wild rice, which is our most sacred food. Time is of the essence, and I ask that you direct the Department of Natural Resources to rescind water appropriation permit amendment number 2018-3420 until such time as the department consults with the White Earth Reservation and all impacted tribes as contemplated by Executive Order 19-24. Please contact me if you have any questions or concerns, and this will be signed by me. This is a letter that will go out today immediately. On behalf of the White Earth tribe, to have them stop the drawdown and go with consultation, and we'll get that sent out as soon as we sit here and vote on the letter, and we realize that there may be others that might not want to agree on the letter, and we respect that. But do I have a motion to approve the letter that's being drafted on behalf of the Minnesota Chippewa Tribe?
Yes, I motion.
Motion by Mike, seconded by Alan. All in favor signify by saying aye.
Aye.
Opposed? Silent? Motion carried. We will get that. Hang on, man. I want to thank you all for being here and voicing your concerns, and this letter is a result of that. So, Chi-Miigwech to you all. Nancy?
We had the executive order 19-21 in the above paragraph, and you had it right in the last paragraph, 19-24.
Oh, okay.
There was a typo there.
Okay.
And I just wanted to share with our tribal executive committee and some of our constituents the position that we took last week on the easement on the Mississippi River between Oneida and Oneida, Minnesota, which is just about 20 minutes away from Bemidji, Minnesota, and bordering the White Earth Reservation. Our stand was not a No Line 3 protest camp. It was a treaty encampment. We feel that, there's so much injustice there has always been, and we see good things happening with the Black Lives Matter and all those, pride movements and all those good things, and it somehow feels that the brown lives, the brown people are forgotten again, and so we feel, because we're still here and Line 3 violates treaty, we had no other course to take but to occupy that easement because it is our inherent responsibility to protect our water, and that is protected under our treaty. So that was a treaty camp. We were out there defending our treaties, and we invited our non-native allies as guests to uphold their treaty obligation to live in peace and to leave the earth in a better way than we found it. So it was a very powerful gathering. It was nonviolent. We left it in a good way. We got a good report from, the sheriff who honored our treaty. Sheriff Halverson in Clearwater honored the treaty and let us do our ceremony. And then on Sunday, we're 6 days or 7 days in by now, Enbridge delivered a letter to our encampment that said, one, we destructed their equipment, we were endangering their employees, and that they asked us on numerous occasions to leave, and we were destructing natural resources. And I said, Mr. Halverson, I have to deny this letter on behalf of the camp because that is not us. And if we agree to leave under that eviction, if you force us out under that eviction, we're admitting we did that. And we didn't do any of that. So the sheriff says, I'm not going to honor it, and I'll bring it back to Enbridge. And that's why the sheriff never made us leave. But Enbridge didn't like that. So the Northern Lights Task Force was called upon, and they were there at 6 o'clock in the morning to remove us. But through our peace talks with the sheriff, I think we have a good story to tell, and this is what the treaty relationship should look like. So I'm going to say in a good way that regardless what Line 3 brings us, we're always going to assert. We're at a time in history where we need to continue to assert our treaty rights to hunt, fish, gather, and travel. And that means to occupy, because not once did we ever surrender our right to our ceded lands, nor did we ever surrender our water property rights. So we stood there not trespassing. We weren't breaking any law, but yet we were cited for trespassing, and that's something else that's for later, but I'm not going to get into that. But I just want to say we stood there in a good way, and we asserted our treaty rights, and we're going to continue to do that. And we hope that when that happens, that we get support from our tribal executive committee and whatever that might be when that time comes. We wish.
We wish, Nancy. At this point, I'd like to have Phil take the floor with regards to the referendum request.
Yeah, just to clarify with the referendum. So what the referendum would do would essentially be to strike the membership criteria currently in Article 2 and leave it up to the individual, including the blood quantum requirement, and then leave it up to the individual bands on to make the determination on their own enrollment criteria. So just to be clear, when we say leave it up to the bands.
Hey, someone's not muted and we can't hear. Okay, try again, Phil.
Yeah, just to be clear, when we say we leave it up to the bands, there wouldn't be anything in the Constitution related to how enrollment would be. So there would be no quarter blood, nothing like that. It would be up to the individual bands to make their determinations as to enrollment.
By ordinance within the tribe itself.
By ordinance with tribal input or with individual input from the bands specifically.
Okay, any TEC members? Discussion or?
Can you explain that a little bit, Phil?
Here, first. Here.
Phil, can you explain that a little bit better?
Yeah, so right now the Constitution includes, it sets out the membership criteria. What we're talking here is to leave the determination of membership criteria up to the individual bands.
And you're saying that do it by referendum?
The question would be posed to the people before a constitutional amendment. The question will be posed, should we get rid of the current enrollment criteria and leave it up to the individual bands to determine the enrollment criteria?
Okay, you talked about a different vote requirement now on a referendum, right?
There is no vote requirement on a referendum. So a referendum is the preliminary vote to gauge how the membership is feeling on the issue. And then from there, if there's a good vote there, a positive vote, you would go on to the secretarial election requirement. That's where the 30% is required.
Okay, so that would just be a vote, and the referendum would be a vote to see if there's enough support out there to have a secretarial vote.
Correct, yeah. So then if the referendum comes back in the negative, we go back to the drawing board and say, okay, let's try something different. So that's essentially what we try to be accomplished today.
Okay.
Just a question, right?
Yeah, and the referendum would probably be like, should the tribal executive committee authorize a secretarial election to make this change to the enrollment criteria? To leave it up to the individual bands.
Aren't you asking?
Okay, I think we just need a little clarification on this too. How many actual secretary elections have we had? A referendum, but this change would have to still go before a secretarial election after if it's a yay or nay or so. Getting back here with the secretarial elections that we've had for the MCT, do you recollect how many of them we've actually had so far?
I wasn't around. I'm not sure if referendums were conducted previous to those questions being put to the membership as a secretarial election. For the most recent one, I don't think so. I don't think there was this referendum to see where the people are at before going to the process.
April has her hand up. April? April, you have your hand up?
I'm glad you asked that, Farron. I also had a similar question. The purpose of the referendum, is it to define the question that voters would consider at a secretarial election? Or would the question that's posed on a referendum already be defined? And so I'm trying to understand the purpose of having a referendum prior to a secretarial election when the question may be equally defined during a secretarial election, and having the voters turn out and having that process hosted by the BIA and the Secretary of Interior. So just kind of clarifying the purpose of the referendum.
Yeah, I think the purpose of the referendum would to have the question be put to the people to see where they're at on it, right? Because if we get 1,000 votes for, which is what, 12,000 votes less than what we need for a secretarial election, there might be a question on whether, if we can't get enough support for the question, whether it goes forward or not. Or if it gets voted in the negative outright, then obviously we wouldn't go forward with it.
So the TEC would take the information from voters voting in the referendum process to determine the next steps of a secretarial election is kind of what I hear being presented or proposed.
Correct, yeah, absolutely.
This is Kevin. I think it's really confusing to everybody when you look at the criteria on Article 14 and Article 12. The prior secretary elections were just done by the Tribal Executive Committee without a referendum. And me as a tribal member, just sitting back, I would ask the same questions that April's asking right now. And Farron, what is the purpose, what is the true purpose of a referendum vote? Is it to clarify the wording? Because if that's the case, then we need to go back to 2005 and how that happened, because that vote for the secretary election was not done by a referendum process. It was done by a majority vote of the Tribal Executive Committee. And I think these are the big issues that are on the table right now. And the clarification piece, I understand that. To me, is kind of like ridiculous in some manners, because we're asking the membership at this point, if I understand it right, is this the wording that you want? We're gonna give you a couple things out there that, and you gotta choose from, right? Is that how that's working? Then it comes back to the TDC, then the TDC then calls for a secretary election, if the votes are there for the referendum. And if that's the case, then and I'm not trying to argue, I just wanna hear my piece. If that's the case, then I wanna go back to 2005, and that rescinding of that secretary election should happen. Because an interpretation was put into place of 1309, changing the words of that secretary election that the membership or TDC members had no choice to vote on, or former T, however you wanna look at it. So wouldn't in theory that have gone through a referendum process? Because I think right now this is very confusing to a lot of people. If we have TDC members asking what this means and the clarification of it, I'm assuming that the audience has a whole lot of questions in their head right now. Just my opinion, my thoughts.
You know, Kevin, this is Kathy. I know that there are questions, and I know that in the past, when you mentioned 2005, and I believe other referendums that really didn't go, or secretary elections, I'm sorry, secretary elections that did not go before the membership, and this is just my personal opinion, was wrong. Everything that we do here, we represent the people for doing whatever they want to do, not what we want to do. But I think with the enrollment issue, and with 2005, with that secretarial election or that referendum there, that is another issue that needs to be addressed. But today we're looking at the enrollment issue, and I was telling Alan that right now we have a lot of Minnesota Chippewa tribe members, Voice Ford, White Earth, everybody, that are out there that don't understand, number one, the Constitution. They don't understand enrollment. All they know is that they're a band member. They're a member of the tribe. They don't know their language, their culture, because of the boarding schools and what have you. So I think what we can do as a tribal executive committee is, if we do go forward with this referendum, asking for their input, which an enrollment is a huge issue with all tribal members. And we need to give them the information and resources of what has happened in the past and what enrollment means and what the Constitution means. Because in order to reform our Constitution, we need our membership to understand it. And a lot of people don't. I mean, it's reflective in our elections. How many people actually come out to vote in our elections? Not many. And that's sad, because I think, we get down to that 30% of eligible voters, all interpretation or whatever. But, I agree with you, Kevin. It is confusing, but it's something I think that needs to be addressed. We need to move forward with something, and then, like you mentioned, the 2005 issue, maybe that needs to be looked at, but we have to do things as they come, and I would just like to say that on behalf of myself. Any other comments, Bill?
Yeah, just a little bit. So, it's nice because I can look at things with a fresh set of eyes. I've been the legal counsel for 5 years, 6 years. One of the things I don't want to do is repeat some of the things that have gone wrong in the past. So, let's say the 2005 or subsequent proposals are just kind of, they come out of the TDC meeting and that was it. I want to try to get more input and collect more information previous to that. The referendum is a tool which you can do that. I know it may be duplicating efforts, but I think it's still worthwhile, so we're not looking back at these decisions 10, 15 years later and asking kind of, well, why didn't we get more input on it? Why didn't we do this or do that? So that's the idea behind kind of using the referendum as a way to gauge support for or against the proposal, and then from there having that informal question.
No, I appreciate that. I'm not trying to put a monkey wrench into anything. I just want to make my point clear that what I've been screaming about for a very long time, if we're gonna do this, I'm fine with this, and I think that's the proper way to do that. But the improper things that have happened all the way back to travel interpretation 180 is my issues, and every TC member sitting up there have heard me holler about this year after year after year after year. There has to be a point in time, if we're gonna move into the point of changing the Constitution or modifying the Constitution or whatever you wanna call it, we need to be able to act the way that we're supposed to be. And by doing with travel interpretation 280 and the other 13 interpretations that go along with it, were never voted upon by a secretary election nor a referendum process of the Minnesota Chippewa Tribe Constitution. I just want to make everybody aware of that. I'm fine with moving in this direction under Article 14 because I think it's the right way to do it. But we cannot forget about the wrongs that were done since 1980 on the travel interpretation. So I just want to make sure everybody understands that, and these are also important. We can't claim one piece is important and the rest isn't. If all the interpretations were illegally done per se, because if you agree with our secretary election in 2005 that it was wrong, then all of them are wrong. Because they weren't done by the secretary election. And the wording that was changed under Article or the 2005 by adding the interpretation to it is wrong. That means all the other interpretations are wrong. So I just want to bring that to everybody's point that if we're going to do what we want to do under this manner and move forward, then them all things also have to be looked at. And you'll hear me say it again, the next DC meeting, the next DC meeting, the next DC meeting. As long as I'm here, because we need to move forward with all of it. And so I think it's right to push the issue or bring up the issue of Article 14 on the referendum process, but the other issues have to be taken care of also.
Miigwech, Kevin, for your comments. Leonard?
Yeah, I just wanted to make a comment on, we're talking about Article 14 and Article 12. Yeah, we're talking about, is this on? Yeah, we're talking about two articles of the Constitution here. Yet nobody's reading for all of us to understand what the actual language is in referendum. And move forward to Article 12, amendment process. I think if we do a reading here, that, yeah, it's a good idea to do these things. And I agree with Kevin, that a lot of these things were done without the referendum. But let's understand the language that's in the referendum. If the attorney here could read that out for us, I'd appreciate it. Thank you.
Thank you, Leonard.
Yeah, definitely, and I apologize for the oversight. So Article 14 referendum states, I'm talking about Section 1, the Tribal Executive Committee, upon receipt of a petition signed by 20% of the resident voters of the Minnesota Chippewa Tribe, or by an affirmative vote of 8 members of the Tribal Executive Committee, shall submit any enacted or proposed resolution or ordinance of the Tribal Executive Committee to a referendum of the eligible voters of the Minnesota Chippewa Tribes. The majority of the votes cast in such referendum shall be conclusive and binding on the Tribal Executive Committee. The Tribal Executive Committee shall call such referendum and prescribe the manner of conducting the vote. So that's the first step of the process that's being proposed here. And then your constitutional amendment process is different. Article 12 amendment, Section 1. This Constitution may be revoked by act of Congress or amended or revoked by a majority vote of qualified voters of the tribe, voting at an election called for that purpose by the Secretary of the Interior, if at least 30% of those entitled to vote shall vote. No amendment shall be effective until approved by the Secretary of the Interior. It shall be the duty of the Secretary to call an election when requested by 2/3 of the Tribal Executive Committee. So two separate processes. The referendum is a strictly internal tribal process. The secretarial election, the amendment process, is a for all intents and purposes, a federal process and is governed by federal regulations. And that's one of the reasons why I believe the constitutional delegation came forward with the idea to get rid of the secretarial election process. And you could roll that all into a referendum process potentially. So just a note on that.
Thank you, Phil. Any other comments? Do you know where Mike went? We lost Mike. No, not the mic, we lost the mic. Not the mic, we lost Chairman Fairbanks. I'm sorry.
I have a question.
Good one. Yes, sir.
Here's Justin again. Kevin brought up a real good point, the 180, I-80 or whatever. This body has done a lot of changes to our Constitution through resolution and all of these other acts that they do. What does our Constitution before they said all of this stuff say? Because I remember a different Constitution than what he's reading off of that said that we had to have a referendum vote, because ultimately blood quantum change is an amendment to our Constitution. And you're supposed to have that vote, and then we're supposed to get together, have a vote, send it off to the Secretary of the Interior, looks it, and then they send it back for another vote. And it's supposed to be done within a certain amount of time. It's like 90 days or something like that, you know? And that's to make sure that we're doing what we want is in our best interest. But when they passed 180, I-80 or whatever it is, the TEC took a whole lot of power from us as people, because in our reality, our treaties, we are the sovereign. We are the sovereign. That was before we had any of this. This year, all these people, when they talk about, oh, that bad IRA government, they are the IRA government. These are the very people we're talking about. But yet they go, oh, that bad IRA government. Yeah, these are them. And they've been making decisions all these years and not listening to anybody. That was the whole point of, back in the day when Marmon Penny, Mr. Roy, Ray Belcourt, all these guys, Jim Weaver, all these guys that stood up to this stuff before. That's what they were saying all this time. But they didn't listen to them. Just like in '96 when they revoked our corporate charter. That's what established our business. When they revoked our corporate charter, they dissolved this body. This doesn't exist anymore. But here they are making decisions for us. What does a corporate charter do? Anybody answer what a corporate charter does? See, I'm a junior right now at Bemidji State University, and this is the stuff I'm studying. Corporate charter establishes a corporation, business. That's what an IRA government is. They gave us a constitution. They gave us a constitution and a corporate charter. That wasn't something that we decided on. Before that, we had Grand Council up until the 20s, where we all had say. We all came together and we make decisions as a whole. But when they usurped all of that power, that's why you got all these people that are disenfranchised and don't show up for meetings. Same with this, this whole Constitution reform. Yeah, back then, look at how many people used to show up at the Shooting Star for that. They used to take out all the partitions, and we'd fill that whole room. But then they started trying to pass all this stuff against our will, so less people showed up. Now it's, a handful of people that are delegates, and we don't know what's going on. We back home don't know what's going on. When are these meetings? Where are they being held? We're left out of it. But yet these people make all these decisions. And if it comes to that, then how is Fond du Lac able to sign an agreement with Enbridge without a referendum? Because that directly affects MCT land. That takes a referendum. They have no authority to do that. Whoever signed that bottom line should be sitting in prison. Because they leverage a foreign corporation of power to come in here and do something that no government's doing. They're the ones bankrolling Northern Lights Task Force. Got our own tribal cops fighting alongside them. All these Public Law 280, all this other stuff wrapped up into our Indian Gaming Regulatory Act. We have a right to police ourselves. We have a right to self-determination. And you know, what they do usurps all of that. Takes all of our power away. It's not right. That's all I got to say about that. You.
Miigwech. With that, we'll move forward here, and I will call for a motion to approve a referendum to all the MCT tribal members regarding the enrollment process, that it be, the question be asked that it be given to the each individual bands to determine enrollment for the tribal membership under the MCT.
To clarify, you're saying you're requesting a resolution be brought forward to call for a referendum?
Yes.
So that we can see the language before we vote on the
Yes.
resolution?
Yes.
Okay.
I have a clarification as
Oh,
well.
I'm sorry, April, your hand was up.
I think it's really important that in either choice that the TEC makes for the referendum or for the Secretary election, that the voters have a clear question, and that it only in regards to enrollment, so that we can be most clear and most defined. And then also very clear with voters that in participating in the referendum, that doesn't actually physically make the change that they're anticipating. And so we still have to go through, under our current constitution, the way it's structured, the Secretary of Interior hosting a secretarial election to actually have voters ratify that change. So just kind of making those 2 points, and regarding education of voters, but also clarity of the purpose of the referendum and what question we're asking them, so that is clear as we move forward. So I just want to acknowledge that. Am I on the same page as everyone on the board here?
Yeah, I believe so. Go ahead, Alan.
I just want to reiterate what I heard Phil say, that the natural course, the natural outcome of assuming that the referendum passes, assuming that the secretarial election, all hurdles are leaped. The outcome will be the elimination of blood quantum as a requirement within the Constitution, and that each band by ordinance will define its own enrollment criteria, and the Minnesota Chippewa Tribe still remains as an organization. This is what I heard you say, Phil. Yes?
Yep.
Motion.
Motion by Alan Roy. Is there a second? Second by Theron. All those in favor signify by saying aye.
Aye.
Oh,
Kathy, I still have a discussion question. You know, I thought that the delegates were gonna bring each nation, reservation, their information back to the people on this.
We have.
Yeah,
Point of order, it's not a vote.
Point of order is just we're on a vote.
Okay.
So, all in favor signify by saying aye again.
Aye.
Opposed?
Can Alan just repeat his clarification? I couldn't hear very well. I apologize.
Go ahead.
Okay, so the clarification was from Phil that assuming that the referendum passes, assuming that the secretarial election passes, the outcome of this decision will be.
Please come to the front. Someone from payroll, please come up to the front.
The outcome of this decision will be the elimination of blood quantum as an enrollment requirement in the Constitution, and that each band will adopt its own ordinance establishing its own enrollment criteria.
By ordinance.
By ordinance.
Yeah,
that
is, idea.
Opposed? Silent?
Well, I guess Kathy, my question is, like earlier was just, the delegations never gave me nothing official. So I guess I'm gonna have to be,
Silent?
until I hear from the people
Okay.
that I'm silent.
Okay, Mike votes silent. Motion carried.
What?
Kevin, did you vote?
Yeah.
He said aye. Okay, all right. Okay, well, we have a direction anyway, so, moving on, let's go to the liquor licenses.
Kathy, I guess I have a question, I guess after this vote, I'm really confused about why do we have delegation?
We're doing constitution reform,
Yeah.
and the constitution is not just enrollment, it's the entire constitution. So the constitution delegation is extremely important and is to this point. But like I said, and I'm not, I'd like to see a direction from the TEC with regards to how to deal with the enrollment issue, because it is such a difficult issue to deal with, and there's the different various, how do I say that, factors that play into it. But if we can get an answer from the people to determine what direction that may or may not be, they may not want that. That's up to them. So that's what this is all about.
See, just like Kathy's speaking on, each tribe and their membership should have the exclusive right to determine their own enrollment criteria. And then we still be part of the MCT tribe.
Yeah, but I guess my question was, the delegations that we have back in White Earth, have consulted with myself, or a letter given, to my office in which direction that we would like to go to, and even the question itself on the referendum or what we're voting on is, what's the question? Is the question going to be on the ballot? Are we in?
That'll be in the resolution.
Okay.
That will be in the resolution.
was a vote to develop resolution.
Okay, all right. Does that answer your question, Mike?
Yeah, I was just really confused. So.
Okay. All right, moving forward, we're going on to liquor licenses. We have a liquor permit from Bones Incorporated. Oh, I'm sorry. Go ahead.
Yeah, Wobble, Starbuck, and Mississippi Band. They did a lot of Mississippi Band in Beach Lake and White Earth and Slotten, Sandy Lake, and all that. But we're never talked about. And I see what you guys are doing, and probably just passed another resolution that sometime in the future will just have to be rescinded. I kind of think that maybe there's some power grab stuff going on here with the individual RBCs. You want to put it down literally, but you already have that authority. You know it. Mille Lacs goes and someone wants to enroll over there, and Mille Lacs says no. Do you guys do anything about it? Is there any recourse for that person that just got told no? You guys just rubber stamp what Mille Lacs said, and vice versa, all around. Each Lake decides something, y'all just rubber stamp it. You already have that power. You're already deciding as individual RBCs who's going to be allowed to be a member of your band. So now you're just going to put this in here, and you're just, I think, clouding the issue. And why I think you're clouding the issue, I think that message is clear. What quantum requirement has got to go? It's as simple as that. And then you cloud the issue back up by saying, well, yeah, we'll address that. We'll take out, we'll address Article 2. We'll take those things out of there. And then we'll also at the same time require that the individual bands can do that deciding for themselves. Now, you already do that deciding for yourself. The difference is, once the secretary, who does not do his job, does not uphold his is trust responsibility to the individual members. Right now, we theoretically can say if we're denied, we theoretically are supposed to come to you guys and say, well, I just made a bad decision. But you guys don't listen, you just rubber stamp it. So theoretically, we're gonna be frustrated, and we're supposed to go to the Secretary of Interior and say, look, these guys are screwing me over, and these guys won't uphold their responsibility, and so now they're gonna have their little power grab here, so they don't have to do any rubber stamping anymore, but they're gonna end up doing the very same thing they've been doing. So why is it that you can't answer the simple question and ask the simple question to the members? And go ahead and meet that 30%. Okay, to the members, should we keep blood quantum? Yes or no? That's the simple question, and you don't have to cloud it by asking that question plus this and that. Should the governments, the local ones, and do this and do that, and confuse the heck out of the people? You know? Blood quantum has got to go. That's the message that I've heard from everybody I've talked to. So many people, their children, their grandchildren, are not allowed to be who they are. And they walk around with this thing in their head, well, I thought I was a Anishinaabe, and I was just told that I'm not. So they have identity problems, which leads to a lot of issues, maybe drug issues, who knows? Because they don't know who they are. We know who our people are, who our children are, who our grandchildren are, who our tribal members are, even if you guys don't. We do. So, I'm just saying, I think you guys probably just passed a resolution that's going to make things more difficult than easy. And maybe have to be rescinded in the future, like other things happen. By the way, whatever question you ask, whether it's a simple one like remove blood quantum, yes or no, or whether it's a complicated one, remove blood quantum, yes or no, and change the Article 2 this way and that way, and allow these tribal governments to do this and that, and a really confusing question. We'll have to meet the 30%, right? That's what the Constitution says. Well, then how come in 2005 they didn't meet the 30%? How come in 1972 they didn't meet the 13% or the 30%? Are those, like in 72, the one that the first wedge to separate us as a people? I remember in the 60s coming up north with Mom, and I was a tribal member. I was Chippewa, and I could go to anywhere. Anywhere, Mille Lacs. I wasn't enrolled at Mille Lacs, but when I went to Mille Lacs, I was a tribal member, and I was there. I was one of the people. After 72, y'all started dividing us. Today, y'all want to be your own separate nations. That's really confusing to a lot of people. It's been confusing to me. I'm just hoping that you just didn't. If you're going to require any kind of secretarial question to the people, and if we have to meet that 30%, I want you to go back and say, were these waivers that happened in earlier amendments that allowed less than 30%? Is that real? And are those legitimate changes? Or maybe Amendment 1, 2, 3, and 4 are all illegal. Answer that question, because what if we have a vote? Is it even going to be a legal vote? Can you give us some guidance on that?
Thank you, Wally. Millie?
Emily from Westport. There was two things that I kind of wanted to say. I know we wanted to bring this up for a referendum vote. In one way or another, since 1970, I've been involved with learning the Constitution, learning Boysport bylaws. And so I'm I'm kind of familiar with a lot of them, with a lot of how it works, at least from boys sport, perspective. I've been, the election judge at boys sport through, I think about 5 or 6 elections, up until the last kind of violent ones, where, I hate to bring this up, but I'm going to. The attorney that was supposed to be representing us on our certification, there was a protest for our election, but the attorney that was supposed to represent our band was also representing a couple other bands, and then the day before that he was due to come to boys sport, he got beat up. And that night, we got the message, but that night I also got a personal phone call from the lawyer's wife, and she was crying, and she did not want her husband being a part of any of this anymore, and she asked if our band would represent ourselves at this protest, which, yes, I did. I told her, keep him home, because, yeah, I know, it was scary. I think he got a broken arm or something was going on. And so then the next day I went into the court, the tribal court that day, and I had people standing there in my face, hollering and yelling at me, and I didn't even get a chance to say anything. And I thought that, we were gonna come to fisticuffs, because there ain't no way I'm gonna let somebody, a man, who had won the election, but then protested his own election. I mean, he got elected, but there he was filing a protest. But I'm not gonna let him hit me. I'm not gonna let anybody. And in the middle of all of that too, at Nut Lake, I was kind of questioned by everybody, even my own parents, as to whether our election was fair, whether people got their ballots, whether those ballots were even counted, and that really hurt me. That hurt me, and I had to defend my staff when we were at work, to make sure that we had a safe place to be. Now that's how important I feel this Constitution and these bylaws are. I mean, there may be stuff wrong with them, there may be other things that needs to be changed in them, but I believe in that to the point that I will fight anybody that questions me on my beliefs and my stance behind the Constitution of the MCT. And this goes the same thing for this water race, that you guys keep coming up and you keep yelling at us to come stand with you, is behind you at these water things. Well, if all 200 people that live in that lake and all the 150 people that live in Lake Vermilion go running down to White Earth to stand behind you, what's to stop them from coming in here, because we're not here to defend our own places?
Then we would have your back.
No, after Enbridge is already here and already wrecked the lake, then you're gonna come stand behind us? I don't think so. But I also want to make sure that that we do get this to the referendum, because even though it's going to be put on a ballot and sent out, the delegates are not going to be sitting still. We're going to be out there. We're going to be handing out pamphlets. We're going to be handing things out to people to let them know We would have been doing this in 2020, but everybody knows what happened in 2020. So just let this go and let the TEC do what they're doing now. The delegates are gonna pick up the ball and get going on our part. You guys that are doing the water stuff, go do your part. As you know, there's only so many people to go around. We can't all be running willy-nilly. And now I made my choice to stand behind this Constitution. I would dearly love to go out and help the water protectors, but I can only be in one place and concentrate on only one thing at a time. And the other thing is, in 2020, I got to news in 2019 that I had cancer. So I spent the whole 2020 battling cancer and trying to stay away from COVID, which is why I still wear masks, because I'm just getting my immune system back up. And so I'm putting in a plug that you guys wear your masks.
Miigwech Millie. Okay, moving forward, we have the liquor application for Bones Incorporated. Do we have a motion to approve the liquor license for the Bones Incorporated, located in Waban, Minnesota?
Motion.
Motion by Mike, is there a second? Second by Alan, all in favor signify by saying aye. Aye. Opposed? Silent, motion carried. Okay, next we have clarification of information provided by Secretary Treasurer Roy.
Thank you, Ms. Chambers.
Alan, if I could just excuse you. For those elders or people that are in the audience, we do have lunch available from the Minnesota Chippewa tribe. It's in the next room. So please, if you need to eat, please go eat.
Thank you, Ms. Chambers and members of the TEC. Appreciate you guys calling the special meeting related to the clarification around the issue of the 30% criteria in order to amend the Constitution. I know folks have spoken about this issue at length. We certainly spoke about it. I presented information at the last meeting, and I'm here to present a little bit more information here today. To summarize before I read my written statement, what I'm asking for is straightforward, just very simply, is I'm seeking clarification from the TEC on this issue today, okay? I'd like a clarifying decision made on this today. And I'll just go along, I'll just jump right into it. So the question I have is on the MCT Constitution, Article 12 Amendment, on if at least 30% of those entitled to vote shall vote, means what? And Ms. Chambers and other members of the TEC, my name is Alan Roy. I'm the Secretary Treasurer of White Earth Nation and a member here on the Executive Board. I'm here today seeking clarification on the revised Constitution and bylaws of the Minnesota Chippewa Tribe, Article 12, which states that if at least 30% of those entitled to vote shall vote, no amendment shall be effective until approved by the Secretary of the Interior, means exactly what? In Hudson v. Zinke, which had cited the Wadena versus Midwest Regional Director, and 3 members of the MCT separately challenged a November 22nd, 2005 secretarial election conducted by the defendants, in which only 6,552 out of 34,153 eligible members registered to vote, and 4,989 ballots were cast for 17% tribal participation. Clearly, there's less than the 30% standard. On or about November 22nd, 2005, there was a press release issued which stated a total of 6,500 qualified voters registered for this election, meaning that at least 30% of those entitled to vote cast their ballots in accordance with Section 16 of IRA of 1934 on June 18, as amended. On or about April of 2021, I had spoken with the executive director, in which it was indicated to me that 22% of qualified voters registered to vote, and that the MCT had 34,000 voting population entitled to vote shall vote as the benchmark in 2005.
Alan, can you move back just a little bit from the mic? You're just a little too close.
All right, and then the 74th Congress on June 15, 1935. And these are, the things I'm about to read here are references that specifically talk about the standard. Just real briefly, when the only way we can amend the Constitution is the same manner in which it was adopted, okay? From day one to present. From the early 1930s there to present. And so the 74th Congress on June 15, 1935 had stated and provided, however, that in each instance the total cast shall not be less than 30% of those entitled to vote. Another Department of Interior memorandum on March 9th, 2020 supports this language, and they interpreted to using the two-step analysis articulated in Chevron USA versus Natural Resource Defense Council in reviewing an agency's statutory interpretation. First, we examine, quote, whether Congress has directly spoken to the precise question at issue, and if the intent of Congress is clear, the inquiry ends. And the department, quote, must give effect to the unambiguously expressed intent of Congress. Step one, conducted using traditional tools of statutory construction, included, quote, including an examination of the statute's text, legislative history, and structure, as well as its purpose. Furthermore, U.S. Code 25 U.S.C. 5127 procedure also references this related to the IRA, and the procedure as published on those and allows in effect on April 23, 2021 stated, quote, adopting a constitution and bylaws or amendments thereto, provided, however, that in each instance the total vote cast shall not be less than 30% of those entitled to vote. It goes on further here, Ms. Chambers, after the furthest review of the tribal constitution interpretations, which I just want to clarify, I do not, as a TEC member, I do not agree with those interpretations. For those folks listening at home, I think they're extra constitutional and also unconstitutional. But in accordance with those interpretations, ordinance number 7-86 states that one resident eligible voter shall mean all enrolled members of a band who reside within the boundaries of the reservation. And in 1986, the TEC had interpreted resident eligible voters for Article 10, Section 3, which stated that all enrolled members of the band who are 18 years of age and otherwise qualified to vote. The second interpretation, 40-81, states field solicitor of the DOA Department of Interior had issued an opinion by letter dated November 19, 1980, directed to Edwin L. Demery, Area Director of Minnesota Area Office of BIA. And in the letter, it's being signed by Mariana R. Schulstead, was field solicitor, and the said letter concluded that, quote, we thus conclude that under the present provisions of the MCT revised constitution and bylaws, the TEC may not validly create a subordinate corporate entity such as they have attempted to do here. A constitution amendment would be necessary to give them such power. The MCT TEC interpretation 4-81 further states that the Handbook of Federal Law by John Cohen, where he stated on page 34, thus, in accordance with the general rule applicable to foreign treaties, the courts will not go behind a treaty which has been ratified to inquire whether or not an Indian tribe was properly represented by its headmen or determine whether a treaty has been procured by duress or fraud, and declare it inoperative for that reason. New York, United States v. New York Indians, 173 U.S. 464, 1899. U.S. versus Old Settlers, 148 U.S. 427, 1893. And the treaty, after executed and ratified by the proper authorities of the government, becomes supreme law of the land, and the courts can no more go behind it for the purpose of annulling its effect and operation than they can behind an act of Congress. Fellow v. Blacksmith, 60 U.S. 366, 1856. Another example that had not been included, an amendment or vote under Article 12 of the Constitution in 96, was a letter by Jacobson, Buffalo, Shossler, and Magnuson Limited, signed by James Shossler, which stated, the Technical Corrections Bill was passed by Congress in February. Included as section 13 of the bill is the following language. Requested MCT to surrender the charter of incorporation issued to that tribe on September 17, 1937, pursuant to section 17 of the Act of June 18, 1934. Charter of incorporation is hereby revoked, section 13. This is what my friend Justin Keyser was alluding to earlier, that there's been some misdeeds that's been happening over the years here, and I do appreciate the TEC taking the time to try to correct some of this. The 100th Congress, Public Law 100-581 and 88, enact to establish procedures for review of tribal constitutions and bylaws or amendments thereto pursuant to the Act of June 18, 1934, stated B. Any constitution or bylaws ratified and approved by the Secretary shall be revocable by an election open to the same voters and conducted in the same manner as provided in subsection A for the adoption of a constitution or bylaws. And A, any Indian tribe shall have the right to organize, and any amendments thereto, when one, ratified by a majority vote of the adult members of the tribe or tribes at a special election, section 9. On August 22nd, 2017, Mr. Brodeen's Zoggy Bagong presentation on the constitutional history excerpt stated that, quote, in the introduction, an important aspect of any constitution is to outline the rule of law for the nation and creating a system of governmental powers that outlines the rights of members and responsibilities of elected officials. And he says that while Fond du Lac was 10 votes shy of meeting the 30% threshold required by law to make the IRA election valid, oddly, the solicitor held that since a majority of votes cast were in favor, they have not voted to exclude themselves. The Constitution requires that 30% of those entitled to vote must do so for a valid election. If 30%, and if a majority of the voters agree of that 30%, then the Secretary of Interior approves or rejects the change. Unfortunately, our current version of the Constitution creates confusion and disagreement because the interpretations of the various sections combined with the TEC interpretations and ordinances sometimes differ, section 14. Then, with the Department of Interior from 1947, under the 10 years of tribal government of the IRA by Theodore Haas, who was the Chief Counsel of Indian Services, stated that amendments may be ratified by the tribe and approved by the Secretary in the same manner as the original Constitution and bylaws. However, by the Act of June 1535, this period was extended another year. The amendment to the Act modified this rule so as to require a majority of those voted in an election in which not less than 30% of those entitled to vote actually vote. On November 17th and October 27th, 1934, the total population for the Consolidated Chippewa Agency was 12,437. The voting population was 6,351. The votes for yes was 1,898. The votes for no was 344. The MCT had 35.3% of the population entitled to vote shall vote under section 15. Minnesota Chippewa Tribe Election Ordinance as amended to 11.9 and 15 under chapter 1, section 1.3D and D2C states that applicable law means the law of the jurisdiction in which a crime is prosecuted. And finally, the following tribal, federal, state of Minnesota, and U.S. constitutional laws protect the rights of Indians or Anishinaabe people. The Constitution, Article 13, Rights of Members, states that all members of the MCT, the Minnesota Chippewa tribe, shall be accorded by the governing body equal rights, equal protection, or the redress of grievances and due process of law. We are bound to protect our people. The Indian Civil Rights Act of 1968 states that no Indian tribe, in exercising powers of self-government, shall deny any person within its jurisdiction the equal protection of its law. And 9, pass any bill of attainder or ex post facto law. Meaning you can't pass something now and push it on people in the past. The Constitution of the State of Minnesota, Article 1, Section 11 states, attainders ex post facto laws and laws impairing contracts prohibited. In August 2017, the House Research stated prohibition against ex post facto laws under Article 1, Section 10 of the Constitution and Article 1, Section 11. The Minnesota Constitution prohibits the state from enacting ex post facto laws. So it is all the way from the top, from the U.S. Constitution on down to every constitution. U.S. Constitution, Article 1, Section 9, Clause 3, no bill of attainder or ex post facto law shall be passed. Both federal and state governments are prohibited from enacting ex post facto laws, and the court applies the same analysis whether law in question is a federal or a state enactment in Calder v. Bull, U.S., United States v. Powers. The guiding federal Indian law principles by the Department of Interior, Office of Solicitor stated by the MCT that the interpretation number 481 is set out in the Handbook of Federal Law by John Cohen. The foreword stated that Indians have legal rights. Is a matter of little practical consequence unless the Indians themselves and those who deal with them are aware of those rights. The principle of Indian self-government was carried to a new phase when the Indians themselves were asked to vote on whether or not the law establishing self-governing powers should apply on the different reservations. The great majority of the Indians voting on the question voted in favor of the Indian Reorganization Act. The Handbook on Federal Law, Chapter 7, the Scope of Tribal Self-Government, Section 2, says that the derivation of tribal powers, in either case, the laws of the Indian tribe owe their force to the will of the members of the tribe, on page 122. And on page 124, the contention that the United States courts had jurisdiction, claim of federal jurisdiction was based, provided. And Congress shall by appropriate legislation secured to them in orderly government, they shall be subject to the laws of the U.S., and each individual shall be protected in his or her rights and their property, person, and life. Handbook of the Federal Law, Chapter 7, Section 3, and the form of tribal government says that for the tribal organization, if a tribe or reservation adopts the Constitution and bylaws in this manner, such Constitution and bylaws may thereafter be amended or entirely revoked only by the same process. The Handbook of Federal Law, Chapter 8, Personal Rights and Liberties of Indians, Section 1B, Constitutional Protection of Indian Voting Rights, Section 2 states, the Congress shall have the power to enforce this article by appropriate legislation. Chapter 8, Section 10, Civil Liberties states that the category of civil liberties thus defined includes certain subjects which are elsewhere treated in this chapter, such as the rights of citizenship and the right to vote. As previously stated in the motions and questions, Ms. Chambers and my honorable members of the TEC, a motion was made on April 29, 2021 in the Legislative Subcommittee and approved and amended to include clarification instead of interpretation will be reflected in the minutes. And the following question was presented on April 30th, 2021 to the TEC for clarification and approved, which will also be reflected in the minutes. The question, Ms. Chambers, is on the tribal clarification on the revised Constitution and bylaws of the Minnesota Chippewa tribe. Minnesota Article 12 amendment language on if at least 30% of those entitled to vote shall vote means qualified voters registered, or that in each instance, the total vote cast shall not be less than 30% of those entitled to vote, or the MCT Tribal Executive Committee's written clarification as to the meaning and understanding of its constitution for Article 12. That concludes my remarks.
Thank you, Alan. As always, it's always difficult to, it's all a matter of interpretation again. You know, we talk about interpretation. So right now, the question is 30% of those entitled to vote means qualified voters who are registered. Or that the total vote cast shall not be less than 30% of those entitled to vote. So the questions are really quite complicated. First off, or the MCT Tribal Executive Committee's written clarification as to the meaning and understanding of its constitution for Article 12. The 30% has always been an issue. And I think what you're wondering is, today, you want an answer. What is that 30%?
Yes, that's correct. I want to know, what does that 30% mean? And it is my opinion that the 30% is prescribed in the tribal constitution. That is the standard. So I'm looking for clarification from this body, because it's very important, especially if we're engaging in some of these amendment processes.
Mm-hmm. Comments?
Article 11, Article 12, and Article 14 under the principle of the referendum. Each one of them gets you to the point of it's written in exactly one way, that 30% of the entitled to vote shall vote. It doesn't say anything about registered voters, it doesn't say anything other than that, but that. So, that's where I'm at, and that's where I've always been.
Okay, Arch?
Yeah, I guess I have some comments too here on this issue. The 2005 secretarial election, Kevin, when you spoke earlier, you were right, it was a big mess, you know, and it wasn't done right from the beginning to the end. But at the end, we recognized and acknowledged in the last few months here, I want to thank Alan for asking the MCT questions and getting documentation. I want to thank Kathy for making sure all of us TEC members get this information. Because looking at all that information, it was like a puzzle, you know, you start putting it together and you've seen all these illegal acts and all this unconstitutional stuff that we're talking about today. You know, I'll give an example, you know, if you look at the press release after the secretarial election, you look at the sample ballot, you look at the election ordinance language, and you look at the MCT constitutional language, they were all different wording. They should all been one. They weren't though, they were all different wording. That's a big mess. But the bottom line is, you know, we're the Minnesota Chippewa tribe. And we were adopted and approved in 1934. And right today, under tribal and federal law, it's required to have 30% of the vote. And yet, this is a constitutional issue, so there isn't no statute of limitations on addressing this and correcting it. Maybe we're not correcting it or addressing it in a timely manner, because we should have been talking about this maybe in 06, 07. But it's, you know, never too late, you know, and it's better late than never to address and correct something. And we as a TEC body here swear under oath to uphold the MCT Constitution and the United States Constitution. And right now we're violating all our people's rights, 40,000 plus people. We're violating their rights by these unconstitutional secretarial election amendments. Amendment A and B is unconstitutional. How can we, as a TEC body,
implement rules and policies, procedures on our band members that are filing to be candidates? How can we implement more on there when we know for a fact that we never reached that 30% threshold mark to approve this? You know, it's illegal, it's unconstitutional, and you know, it's up to us to uphold the Constitution and follow this and address it and correct it in a proper way. You know, so I just wanted to bring them issues up because under our document that we've been under since 1934 and under federal law, we never met that 30% requirement. And you know, we can't pick and choose when to follow the 30%. We gotta follow it from the day it was adopted, and that was 1934. So my recommendation to this whole TC body is we have to address this and correct it in a properly way and follow and uphold the MCT Constitution and the United States Constitution. You know, because this is out, it's public now. We've received documents, we received the paperwork for the last few months putting all this together. So now we know for a fact we never met that 30% criteria. And it should be up to the people, and the people should be voting on any kind of waivers. It shouldn't be to the Secretary of Interior or to the BIA. We have that right, and that's our right, you know, and that's under this document that gives us that authority as a people. That's all I want to say, miigwech.
Miigwech, Archie. Phil?
Yeah, just one thing. So the intervening event that occurred that makes this a question now, that wasn't a question in 2005, is the final rule that came out in 2015 that said that the BIA would finally give credence to the band's or the tribe's interpretation of its own document. Previous to that, the federal election or the federal secretarial election requirements were set via federal regulation. That regulation had a strict process that allowed for or called for the registration process. So that's what happened in 2005. From a legal standpoint, the 2005 amendment was approved by the BIA. It was challenged, and that challenge failed. So I'm not sure, you're talking about statute of limitations. The way to fix that would have been to bring an APA action within 6 years. That challenge did fail. So for all intents and purposes, from a legal standpoint, looking at it pursuant to this structure of law, I think it's a settled question that the 2005s are the same, but the intervening part is the 2015 final rule, and now we can have some say in what we think that our document says. So that's all I'll say. And I think I've been consistent with that for the past 2 years, 3 years with that.
Okay.
Yeah, and I just want to add, there was 3 individuals that contested this in 2005, and 2 of them are in the spirit world, the late Chip Wadena and his son Tony Wadena. But we also have a White Earth tribal member here named Frank Beebo. He's a White Earth band member. He's also a lawyer, and he contested this too because of the 30% requirement that we fall under Article 12 of the MCT Constitution and the U.S. Constitution, federal law. And do you have any words you want to share, Frank, or any thoughts?
The first thing I guess I would say is this is the tricks of law that make people hate attorneys. Our Constitution hasn't changed, and what we appealed on hasn't changed, and it's just that the BIA has changed their opinion, and that just seems ridiculous to me. It was wrong when they did that, and I think what Alan and other people were talking about, these waivers. I don't know how you can have a waiver from an agency that supersedes the Constitution.
Yeah.
That's the real issue. So I They got it right into their mind because they had the wrong rules going on. And now they're getting to the right rules. We have a lot of decisions like that through history that have gone against us. We have a lot of things we could imagine and go back and look at. But, you know, in the sense that we're stuck, I don't think we're stuck. I think Bill's gonna find a way out of this, and we're gonna find it internally. You know, we can fix this here, we can say that it was wrong. That's what I tried to suggest a long time ago, is we can say it was wrong. That's the sovereignty aspect of this. I understand the DIA wants to say that it wasn't their fault. Maybe that's what we're talking about here. But we weren't wrong then, you know, and we can still act. That's what I would say, so.
Yeah,
Speak with Frank.
and I would say that in order to change the Constitution, you have to go through a constitutional amendment, something that has been approved by the BIA already. But, I mean, it's as simple as that.
I agree with all that, but I just gotta throw my 2 cents in on all this. All the ones who aren't here with us anymore, Mushku Babu, Margaret Mennipenny, Dale Hanks, Roxy, Doc Rose, and others, they were never wrong on the arguments that they were making, because we're discussing them right today. But it's sitting in front of us and always been here, and I'm just gonna say, and the ones who know me, that I've been screaming and hollering about this for 20 years, simple ordinances put into place can take care of some of these things that been put into place. Call them illegal, call them whatever you wish, but no matter what, we go back to 180, and so the BIA or the Secretary of Interior claim deference. It doesn't mean anything to that point. It's still wrong. And if we're saying, and this is my opinion and my opinion only, if we're saying that we have to change these things, we have to have a secretary election, I would disagree with every one of you, because they weren't done by a secretary election. So why do we have to change them with the secretary election? It's sitting in front of us, and we choose not to address it, and we chose not to address it for many, many years. And what Alan's bringing up, I'm glad that you did it that way. I guess by doing it a simpler way, by just reading the Constitution, doesn't work. But these arguments have been here for a very, very long time. So when I look at the principles that exist in front of us, it's at our doorstep. We just have to make the move to change it. It could have always been changed internally. You guys, 2005 secretary election, they added words to that based on an interpretation. Hang on, Archie, please. 1309. They added words to what people voted on. So if that's the case, is what we're saying, then why can't, and I'm not saying do the same, but I'm just throwing this out so maybe everybody's on the same page now. Can't you do the same thing? We have the ability within the Constitution to establish ordinances that make things move, or ordinances to enforce articles. So if 13.9 was put into place and is added to the wording of the actual secretary election, and as a lesser crime, right? So we get something that's put in there as an add-on to that, and it's the TDC's interpretation, but what the people voted on, the wording they voted on, and they made an interpretation to that. Well, by ordinance, we can turn around and say, no, that's not it. And I don't believe we have to go through another secretary election to get that. Because if we're doing it, we're saying it was wrong, but to fix it, we have to follow a secretary election. And this is why I brought up 180 at the beginning of all this. It says that Tribal Interpretation 180 gives the sole authority to interpret the Constitution by the Tribal Executive Committee. That's what they did in 180. 280 and all 13 other tribal interpretations to do that. So we're sitting here today going, oh, we need to do a secretary election to change this. I disagree with every one of you if that's what we believe. I believe we have the authority and the ability to put ordinances in place to change this now. We have authority and ability to put ordinances in place to put teeth in the articles of the Minnesota Chippewa Tribe Constitution per se. All right, I'm done talking, Miigwech.
Miigwech, Kevin.
Yeah, I was just gonna say, I agree with Kevin there that, you know, we're being asked to to properly amend the we're being asked to properly unamend the Constitution with 13,000 votes when it was improperly amended with 6,000. That's absurd. It was not properly amended. And the thing is there are no statute of limitations. Like, usually I'm not aware, but this is just my opinion. Statute of limitations are usually reserved for damages, right? So I have damage, you've done damages to me, right? So or statute of limitations for crimes committed or civil litigation. There is no statute of limitation to constitutional law. This is why the Supreme Court makes rulings on the Constitution all the time. Happens all the time. And by your own interpretations, the only one body that's equivalent that can do that is the one sitting here. So to say that we have to go through the same process to undo what was already the wrong process, that just makes no sense to me. And so I have two asks for the body. First ask is, I want to know, and I don't know if I need to do it. I was hoping Phil was going to bring a resolution. He said he was going to bring a resolution. I don't know if he has it. What is the 30%? Because it is what's written in the Constitution. I think that's what I'm hearing from them. That is the standard. Yes, that is the standard now. That'll be the standard moving forward. And the question becomes: is that the standard when it comes to November 22nd, 2005, Amendment A and Amendment B? It has to be. It has to be. It has to be the same standard. It has to be. And so, what do I got to do to move this body to repeal that act? What do I got to do, Phil? What kind of proposal do I need to bring forward to repeal that act?
I already said what I thought.
We already know 30% wasn't met.
What do I got to do? Do I got to present a resolution? Do I got to make a motion to repeal this act?
Repeal constitutional amendment.
To repeal an unconstitutional amendment.
Unconstitutional.
Because it was
unconstitutional.
Approved by the BIA, and the appeal didn't go anywhere.
So the people, Phil?
The people.
You never mentioned the people, Phil. The one equation that's forgotten all this whole argument is the people.
Please use can you guys please use the mics, because, yeah, you got it, Frank.
I was getting ready.
I know you were getting ready, but the young man back there, because we've got our Zoom people, so we got to be respectful so they can hear.
Thank you, Frank.
I really wasn't going to speak today because I think everyone said what they had to say. When I keep hearing someone say that this person has to decide for us, this is why we're sitting here today, because we didn't decide. We were asked to approve the Constitution, not the BIA, not the Secretary of the Interior. Congress had an act, and we bought into it. And unfortunately, we didn't need that 50%.
30.
No, 50%.
50.
They amended it in 1935 for 30%. We didn't have a new election. They took our numbers from 34, and that's how we ended up with the IRA. No, we keep saying we gotta ask someone permission. I thought I heard at the last meeting we were sovereign independent nations. Are we?
Tribal leaders.
Are we sovereign independent nations?
Yes, we are.
Yeah, quasi, but we all signed treaties. You can only do that as a sovereign nation. Now, when I spoke to Danny Linaway, he told me sitting in that chair, he said, don't ever forget who you are. Because at that day, I'd given up. I'd given up on the people that I looked up to. I'd given up to the people that I followed. Because he said they don't understand sovereignty. When you sign agreements, you give a little bit of your power away until you have no power. Until we hear what our tribal attorney says, well, it's okay if the BIA says it is. It's okay if the Secretary of the Interior says it's okay. But your people aren't telling you that it's not okay. We're the people that matter. We're the people in that Constitution that gave you folks the power you have today.
Yep.
And I wanted to say it the right way, Madam President, honorable members of the TDC. I don't want to be negative, because we've had too much of that. We beat each other down too much. I know you guys work tirelessly. I can see it on your faces. A lot to deal with today. Whether something's right or wrong, I don't know who decides that. But what I do know is, if we're gonna say something is done this way, then it should be done that way. So that when our grandchildren grow up and they say, you guys did the right thing, we can say in our history books, like all of the history we read, one day I put all the treaties together and all the acts that were done to us, and watched how everything was taken from us, and reading our Cass Lake Council meetings and saying they speak with a forked tongue. When I hear someone speaking with a forked tongue, I can spot them a mile away. We're either tribal or we're something else. And that's my personal feelings. I get tired of fighting because we got too much to do. We're too far behind to fight with each other. So I apologize for you.
Meekridge for your comments. Frank?
We have a quirky system of government. We don't have the three separated branches, and so we don't have a judicial. And so a lot of times, while I disagree with, the elected people become the judiciary. And under the principles of law, there's been two or three mistakes that were made right at the beginning. When I said, if ever, that was a constitutional violation from the beginning. That's unlawful. And when it didn't meet the 30%, that was unlawful. And I think those two things alone are enough for simple people, and we all are, to acknowledge that it was unlawful what occurred, even if the BIA said it was okay. Now, most of the people that are here weren't here when this was done, but it was done for the wrong reasons, and it was done the wrong way to begin with, because they were trying to prevent people like Chip and Tig and other people from running for office, but nobody wanted to implement some kind of a crime code to prevent people from committing crimes. So what they tried to do was figure out how to prevent the criminals that were known from running for office. So we didn't fix what we were trying to fix. And like Kevin was talking about, we took that microscope further and started applying it to people in ways that it was never intended, just by making another interpretation. So all we have to do really is say it is unlawful. We can see it's unlawful, and we're declaring it unlawful. And we can say it was done for the wrong reasons. And the BIA has now finally recognized it. I think it's that simple myself. That's just me.
Frank, can you explain to everyone how the BIA recognizes it today?
Well, I think the decision says that. I think everything says 30% is 30% is 30%. Somehow we got away from it. And it happened with the TEC wanting to make the amendment go through. That's why they had waivers for the election. Because what happened was when the election happened, you're supposed to have all of the members identified who's eligible to vote 30 days ahead of time. When that was taken away, and it doesn't matter about that part so much, but when that was taken away, it was made so it was same-day registration, and so that everybody could walk in and vote. And that meant that the registration pool became the number to figure out whether it was enough. The registration pool was never enough. That was the whole problem. It's not 30%, it's math. We've been living with a math problem we can all see doesn't add up. We just have to say it. We have to have a referendum to fix this. We're going to get there.
So Phil, what is the procedure? Let's say, let's do a scenario. We propose a new secretarial election, for example, on some of these issues people have brought up, aside from what we're talking about, same principle. And we fail to achieve 30%. What do we do? Who do we inform? What do we tell the Interior Department? We have not achieved 30%. What is the process?
Well, that's what the Hudson v. Zinke case is about, right? So that constitutional question was challenged by the folks at 3 Affiliated, right? So they won in the district court below, they said, we didn't get to 30%, it's invalid. They won that below, they went up above and said, no, the BIA, the Secretary of Interior was right, this is a federal election.
I mean specifically, so let's do a scenario plan. We say we do enrollment, we put it out to a secretarial election, you don't get 30%, right? Administratively, what does the TEC do with the Interior Department? What happens if we fail to meet that threshold?
Yeah, so you tell them you didn't meet the threshold.
That's it. And then the amendment doesn't go anywhere.
Well, no, it still could. I mean, that's what the Hudson v. Zinke case was about. The BIA, or the Interior said, no, it's good, it met the threshold.
Yeah, but in the scenario I'm talking about, if enrollment doesn't get to 30%, then TEC just tells Interior, hey, we didn't get 30%, sorry. That's it. It doesn't pass, right? That's what.
Yeah.
So why can't that same principle be applied? That is the constitutional principle. The BIA waiver is an extra constitutional. It is an extra constitutional mechanism to get away with the constitutional standard.
Kevin? Kevin, were you gonna say something?
Yeah, I was just gonna say, it is applied. It says it. We don't have to ask attorneys, we don't have to ask the Great White Father about this, we don't have to ask the Interior Department, we don't have to ask the BIA, it states it in black and white what it is. So I don't know how we're going around beating around with this is what it says. If you don't reach the 30% entitled to vote, then it's null and void. I don't see why we need to go any farther than that. It's in the document, it's been there. It's been there for since it's been written, hasn't it?
Yes, sir? Alan, if you don't mind.
So I don't know, I would just suggest that this is where you guys want to move it because it recognizing it's illegal, then I would say just make a motion and have a vote, and then if you would feel more comfortable about it, draft a letter to the secretary and say, we have found these inconsistencies and we've decided to move this way. I guarantee they'd probably just say, you guys are right, and then you feel more comfortable.
Thank you for that.
You guys should.
I have one comment.
Go ahead, Kevin.
And I promise I'll be quiet after this. I'm really, this is just blowing me away. But here's my point to it. If we're gonna walk into this and pick out one, I'm fine with that. But when are we gonna go back to the other, when are we gonna go back to the other 14?
You eat a whale one bite at a time.
But if we would just take out 180, doesn't that eliminate the rest of them then? Just my thoughts. You which?
Thanks, Kevin. I think, first off, that I'm asking the committee, whoever's left here, that one of Alan's clarifications was 30% of entitled to vote shall vote. That's the clarification. Is that correct? From the TEC. 30% of entitled to vote shall vote.
What's prescribed in the Constitution is the language that I want.
And this is the language.
Yeah.
Kevin?
One more point.
Yeah, go ahead, Kevin.
I think this clarification was already done one time when I was the president. I just want to make sure.
Okay, do you remember when, by chance?
No.
Okay.
But
we can
if we do it again, all we're just doing is reaffirming it, so I just want to make sure so it's not a confusing piece after that point.
Okay.
I'll move for that clarification.
Okay, motion by Alan to move on that clarification for reaffirming 30% of entitled to vote shall vote. Is there a second?
second with the roll call vote.
Second with a roll call vote by, Archie, I almost forgot your name, Mark. Okay, can we do a roll
I
call?
have a question.
Oh, April.
What are we voting on? And I apologize that I heard all of the discussion, but I don't understand why we're voting on a point of clarification. The Constitution has the language written out there, so
Because we have trouble following.
I feel like we're talking about a subject related to a secretarial election, but we're adding other points that are being made during this meeting. So what is the purpose of the vote?
The purpose of this vote is to reaffirm the clarification of the 30% of entitled to vote shall vote, because there seems to be, how can I say it, misinterpretations of that. Am I correct in saying that? So we're just voting to reaffirm what Kevin possibly said in the past as president, which we will check, that 30% of entitled to vote shall vote.
So I guess as a tribal executive committee, is a vote necessary? It seems more administrative to discuss this language as the Constitution is written. And so, like if we were in Grand Portage, we wouldn't take a vote to do this, to have this discussion. So I think that's why I'm asking what the purpose is.
We already got a follow, and it's already in the Constitution.
Yeah, April, right now we have a motion and a second on the floor, and we've been asked to do a roll call vote. So
For clarification.
For the motion that was made to clarify the reaffirming of the 30% of entitled to vote shall vote, correct?
Right.
Okay. Roll call vote, please.
Okay.
Gary? I forgot Gary was here.
Kathy, you want to respond? You got all this?
Go ahead.
Okay, roll call vote. Archie LaRose,
Yes.
Baron Jackson,
You'll be right back. You ran to the bathroom.
Oh,
okay, Alan Roy,
Yes.
Dick Fairbanks,
Yes.
Fuller Boyd,
Sheldon?
Sheldon's not in here right now.
Melody Benjamin,
He's not in here.
Bernadette Marno,
Yes.
Kevin Dupas,
Yes.
April McCormick,
I vote silent. I don't see a purpose to this vote.
April voted silent. Bobby Duchamp,
Yes.
Dave Morrison,
Yes.
Kathy Shavers.
Yes.
Okay, do you want to go with that vote or wait?
We can go with that vote. I don't know where they went.
Passes.
Yep, motion passes.
Okay, motion passes.
Okay. The other piece to that, Kathy, thank you for that. I want to circle back because I don't want to make an unconstitutional act myself. Okay? So, and I know where that leads, okay? We've learned to be careful in this job. I do have a request. I have a request for, I have a question to Phil, and I think he left, okay. Well, I got my White Earth attorney here then, okay. So I want to know, what are we gonna do about 2005? What are we gonna do about Amendment A and Amendment B? We have just reaffirmed our commitment to the Constitution. This is what we have done. And if I introduce, this is the opinion I'm looking for, if I introduce some language or an act to this body to to repeal. I haven't done it, I want to clarify that, but if I do it, I want to know the constitutionality of that act. I want to know. Because I don't want someone to say that's an unconstitutional act, and then we're going to be going in circles.
Okay.
Let me just
Go ahead, Frank.
Yeah, it just comes down to words. Don't use the word revoke, because you can't revoke it, it takes the people. But you can find that it was unlawful. And that's what you're doing. You're saying we just took a vote, we all agree 30% is 30%, now we're taking a vote to say it was unlawful in 2005. We want to correct it. We're correcting it ourselves. Here you go, BIA. We're taking this out of our Constitution. I mean, that's how I look at it. There might be some other words to say mistake, things were done the wrong way. Things that make it seem like we understand why it was done wrong and how it's hurting us now, if we want to. But we can't use the word revoke. That's right.
Okay, good. So now that we have that established, I'm looking at Phil, and I want some language in there that says, by us doing that we're not breaking the Constitution. My question is different. So, because I sit on here and I have that authority, along with these other folks, to interpret that. So, like how these laws work. What was I going to say? So what I'm saying is, I want to know if I introduce that language, that this body is not going to be accused of being unconstitutional. That's the question I'm asking. I'm going to carry out the act. I just haven't done it yet. I just want to know that it's a constitutional act. It's not outside the bounds of the Constitution. That is the only question I'm asking of you.
So, it is getting kind of confusing to me too, because I wasn't around and I don't understand that whole 2005 situation. So if it's unlawful, if you were to bring this forward, are you saying then you're not going to do it?
I didn't say that. I said I haven't done it yet.
But you want to do it if it's illegal?
No, I want to know that by bringing that, if that act is brought forward, that action is brought forward, that it is constitutional, that it will not be deemed unconstitutional before the action is taken.
My point is, Alan, the MCT Constitution and the U.S. Constitution support you and us on fixing and addressing and correcting issues like this. So I think it's okay.
When was the U.S. Constitution changed by Congress or the President? That's my question.
It was changed when black people were considered 3/5 and couldn't vote.
Through a
And
constitutional
they made
amendment?
the 1968 Civil Rights Act. The Constitution still says they're 3/5 and can't vote. Yep. Don't mind me.
Can I say something?
Oh, I'm sorry. Yes, sir. I'm sorry.
I think if you guys really want to cut down to the bare everything of it, then I think you guys should, I think all of you guys should vote to rescind I-80 that gave you guys all this authority and power, and then you'd reach your 30% vote because it would give that power back to the people. That means that I-80 and any of them other interpretations you got, they go. Because as you see, very many people here. Even when all these people are here, that's just a fraction of how many people are in our tribe. I think if you cut that down, I-80 needs to go. Rescind I-80, and you'll get the people to come back in and vote. That's what I think.
Is that Justin?
Yeah, that's me. How you doing, Kevin?
Hey, I couldn't hear you. Can you repeat yourself, please?
I said that you guys need to rescind I-80 and all the other interpretations. Because that gets it back to the hands of the people. The power that you wield is in the power of the people. It always has been. You have no power over me. I have treaty rights, right to rise, hunt, gather. I can go camp out someone's yard, they can't say nothing. Clearwater County Sheriff was the very first of elected official that ever acknowledged our treaties in that way. That's why that was substantial, and that was significant, because we actually had a member of their government that said, I recognize their treaty rights and that they're able to do this. And that left Enbridge and all these other counties saying, well, what are we going to do? They couldn't move us. We moved on our own. We dictated how that ended. We wrote our own narrative on that, and we chose to march out, clean everything up on our way out, and leave in a good way. And that sheriff said, hey, there wasn't so much as a bubblegum wrapper out there, and I respect that they have these treaty rights and that they can come and do all of this stuff. But that power of the people, you got to do away with them interpretations. That I-80 and all that other stuff needs to go. Quit listening to these lawyers. They talk about bar exam. What's a bar? It's a British accredited registry. I mean, come on, we still got the English choosing. What the hell is going on here with the? That ain't even right.
Well,
Miigwech. Okay, we did get clarification. I know, well.
No, I can't. Here, okay. So I'm trying to give you guys the best legal advice. I've told you that this ability is not in the Constitution. So you guys are the decision makers. I'm not elected by my people to make these decisions on interpreting the Constitution. Like Mr. Keiser said, I'm just a lawyer, okay? That's all I have to say. You guys are the elected officials, you make the decision.
Okay, Alan, whatever you want to bring forward, and we'll move from there.
What do you want to do, Kat?
Bring it back.
You want me to introduce it?
Well, I mean, like Phil said, the ability's not in the Constitution, but I think it's up to the TEC members to decide. Bring forward whatever you want to bring forward, and let's move on. Bring it to a vote then. I mean, that's all I can say. Okay? We have another July meeting, so. And more meetings after that.
I just want to say that, well, my name is Cheryl Jackson, that just remember that whatever you guys vote should be on behalf of the members, because that's who we work for. And, you know, you may think different or whatever, but remember you're voting on the best of your knowledge on behalf of our people. Miigwech.
Miigwech, thank you. Okay, we'll move on. Next is legal with Bill Brodeen.
I just included that memo for informational purposes on the case that we discussed. So that's been provided previously.
Okay. Next we have on the agenda the BIA response to blood quantum resolution for information. Other discussion? Okay, no other discussion, then I'll call for a motion to adjourn. Moved by Archie, is there a second? Second. Second by April, all in favor signify by saying aye. Opposed? Silent? Motion carried. Miigwech, everybody. Try to get something to eat if you didn't get a chance. Next door, and Miigwech for coming to Boyce Court.
Yeah, in '05, it was me, Kevin, and Dave that sitting on this current wire, and all the rest of these are brand new. So, Abel was gone, you know, so, yeah, see all the things that brought to our attention, like the rescue email, and the sheriffs, that's how when you said this, oh, here, share that information, that's when I recognized 4 different wordings on 4 different